So once you file for custody in Pennsylvania, you're going to get scheduled for a lower level proceeding first. That proceeding is usually a custody conference, and it's with a lower level officer as opposed to a judge. So it could be the master or a conciliator, depending on which county you're in. It's an informal process as opposed to a more formal hearing in front of a judge where you would bring witnesses and evidence with you. So at a custody conference, you're not going to be bringing anyone with you to testify. It would just be yourself, the other party, and your attorneys that are in the room. And if you don't have an attorney, it would just be the parties in the room and the other party, if they have an attorney, their attorney in the room. Whether an order gets entered or not will depend on whether there's any type of emergency issues. The master can make a recommendation in Bucks County. The master does not enter the order themselves, but they can draft an order and send it to a judge for consideration. And a judge can enter an ex parte order, meaning that you haven't had an opportunity to present any evidence in front of that judge until you get to a hearing in front of that judge. So at the custody conference, which is the more informal process, you're going to be asked questions like whether there's any type of custody order already in place, or informal arrangements on what your schedule has been. You're going to be questioned on the background as far as where you live, if anyone else lives with you, and also your work schedule, and if there's a support order in place. So it's really important to make sure that you have the facts when you're going to a custody conference, and also what you're looking for, because that's something that might not be specifically set forth in the petition that you filed. So if you have an idea of the schedule that you're looking for, you're going to want to make sure you're crystal clear on what that is so that when you get to that custody conference, you can, relay that information to the master. The other thing that you should always bring with you whenever you go to a custody conference or a custody hearing would be your criminal affidavit statement. So in Pennsylvania, that's now required, and you need to update it as of the date you go to court because things can change rapidly. And those forms are available through the Prothonotari's office if you don't have an attorney, but you have an obligation to update it. And it lists out certain crimes, but also if you're aware of any crimes that the other party might have had. And in addition, if there's any type of protection from abuse orders, you would have to check that off as well. If you cannot resolve things at the custody conference, then it's going to get scheduled for a hearing. But in some counties like Bucks County, you may be offered to go to what's called court conciliation and evaluation services. And that's usually offered when both parties are either seeking 50-50 and one side doesn't agree, or if one party is looking for primary and the other one's 50-50, and they can't agree, then a lot of times the court's going to want you to go through what's called the CCS process. And remember, this is local to Bucks County. Other counties are very different and don't have the same program. But if it is recommended at your conference that you go to CCES, it's a good idea that you agree to it unless you want to pay for a private evaluation, because oftentimes the court will not hear the custody case until you've had an evaluation done. The CCES process that would be offered to you at that conference level is going to be much cheaper than a private evaluation, where the retainer might be $5,000 to $7,000 for a private evaluation, and then you need to bring the person to court. In the CCES process, you're waiving your right to have that expert come to court, and the report that gets generated will automatically go to the judge. However, if you don't agree to a temporary schedule while you're going through that CCS process, you're going to want to still go to a hearing before that process is completed. Otherwise, you won't have a schedule with your children. Keep in mind that if you do agree to a schedule while you're going through CCES, that schedule is probably going to be in place for a long time. And by a long time, I mean it could be at least 6 months to a year before you're in court. So whatever schedule you agree to while you're going through CCES is going to be in place for a long time. So In some cases where a parent might have been withholding before you even got to that conference level, you might be so happy to get anything that you agree to something less than what you want. And sometimes this is not a good idea because you could be stuck with that schedule for a long time. Like I said, 6 months to a year while you go through CCES. In that kind of situation, you would probably want to ask for a hearing in front of a judge to determine what the interim schedule should be. And although a judge will have a hearing, it's not going to be as extensive as it would be for a final hearing, which is where you would bring all of your witnesses when it gets scheduled in front of the judge. At the conference level, like I said, you're not bringing any witnesses and you're not bringing any evidence. So you're not presenting in photographs or text messages or anything else. If, however, there are concerns about the other parties, such as mental health or concerns about drug or alcohol usage, you would want to raise those issues at the conference level. So when it does go in front of the judge for an interim schedule, the judge will be aware of those issues and can address them at that time. Um, just keep in mind that you never have to agree to anything. Sometimes when a party is not represented, they may feel that they must agree to a schedule. And that's simply not the case. That's the court's job to set a schedule. So if you're offered something and you're not happy with it and it's less than what you want, it's very important at the first time that you're going to court that you allow the process and let someone else make that decision. Because if you agree to less than what you want, it's going to be really hard to go and modify that in the future. As in any court proceeding, you never have to agree to anything. And sometimes when you do agree, like I said, it can be held against you because you can't appeal an agreement. So you really want to think about that. But like I said, if it's offered to go to CCES, that's something you probably do want to agree to because otherwise it may delay your case if you have to wait for a judge to order you to have an evaluation. So just keep that in mind when you go to your conference. You don't have to agree, but to be very crystal clear on what you want your schedule to be.